Hi, I'm Nate Gilbert, attorney in San Antonio, Texas, and today I want to talk a little about the valid requirements of a deed in Texas. So if you have an LLC or Series LLC that you are conveying property that you own by yourself or jointly into said LLC or Series LLC, you might be wondering about what are the valid requirements for that deed. Put very plainly, in Texas, the requirements for a deed are that it must state plainly the grantor and the grantee, so who is conveying the property to whom, so that would be you to your LLC, or you and your wife or your spouse, or you and your brother, sister, whoever it is that owns that property jointly with you to the LLC, and the LLC must be spelled out correctly and accurately. So if you have a Series LLC, you're not conveying to the Series LLC, you're conveying to one of the series of the Series LLC, so it must be stated very, very plainly and exactly correct. Second requirement is that it must sufficiently describe the property that is being conveyed. So it must have that description of the property, whether that is a legal description or whether it is a description that says the address, that whatever it is that will accurately describe the property. We always want to err on the side of a legal description, right? We want to make sure that that property is described in the absolute best way possible so that later on there are no issues regarding that. The next one is that it must convey the intent to convey the property. So it must state that somehow, some way, this property is being conveyed, that it is being transferred, sold, whatever it is, it must accurately state that. And then lastly, it must be signed and delivered, signed by the grantor and delivered to the grantee. So make sure that that property deed is actually delivered to the grantee. It can't be signed and then stuck in a drawer and then wait for that to be conveyed. It must be conveyed and transferred to the grantee in order to be valid. So those are the requirements of a valid deed in Texas. It can be a little bit hairy if you have some things that are going on with the property. We want to make sure that, especially for transferring into an LLC, if there is a mortgage on the property, there are some requirements we want to follow with the holders of the note on the property, and make sure that deeds of trust stay intact when we're conveying property. If there are valid deeds of trust on the property, we need to make sure that we're taking those into account when we're drafting our deeds. But for as far as a legal deed, that's kind of the requirements right there. And interesting, you didn't hear me say that it must be recorded. Every attorney is going to recommend very, very highly that the deed be recorded, but it is not a legal requirement. As long as it is delivered, is signed by the grantor and delivered and meets those other requirements, that's what the court's going to be looking for in evaluating a valid deed. So, like I said, if you are transferring property from yourself or you and your spouse to an LLC, Series LLC, whatever it is in Texas, and you have questions about that, feel free to reach out to our office. We do deed transfers for LLCs on a regular basis and can definitely help you out with that.